Hi, I'm Matt Dunn. I'm the CEO of the Queensland Law Society, and today I'm joined by Ian Lockhart, partner of MinterEllison and member of our Banking and Financial Law Committee. And we're talking about the developments in AML CTF. And Ian, you and I were meant to be presenting a live stream a couple of weeks ago on this topic, which didn't quite happen. I guess what has happened, and there's been a lot of movement, I understand.
Yeah, so around about the time we were due to do that presentation, there was a bill that was before Parliament, and we were waiting to see if it would get through and in what form. Well, since that time, the bill has gone through. It went through on the 29th of November and then received royal assent last week, so it's now an Act. And what the Act does, it changes the Anti-Money Laundering and Counter-Terrorism Financing legislation in some fairly major ways. And we've been watching this for, 17 years at the Law Society.
It's been a long journey, it's fair to say.
And significantly for us as lawyers, what it does, it brings into the ambit of the Act a new set of designated services. And you'll recall that under the Act, you're captured by the Act if you provide one of these services called designated services. There's a new table of designated services that deals with professional services, and it lists out 9 new services that will be captured by the legislation. So if you provide one of those services, you will be captured by the AML-CTF legislation. Now, they don't capture us by referring to us as lawyers or solicitors or whatever. They capture us by reference to the 9 services. And this legislation will capture other professions as well. So accountants and business advisors, insolvency practitioners will be captured, conveyancers, and also professional trustees and custodians. So a whole raft of people who haven't previously been captured will be caught by these 9 new designated services. So it's a fairly wide-ranging reform.
So what are these services then, Ian?
So the services include assisting customers in a real property transaction. They would include things like setting up business structures like companies and trusts, assisting in the transfer or sale of a shelf company, assisting in appointment of nominees and directors for companies, in a business context, powers of attorney, things like that. Includes, subject to certain exceptions, the handling of customer monies or client monies. So potentially money coming in and out of your trust account would be one thing you'd be looking at to see whether or not you're captured by the legislation. So as I said, there's 9 services, but a lot of them are squarely in the realms of most legal practices.
Yeah, so that's stuff that a lot of firms would do on a daily basis.
Yes.
So that means probably the key question is, well, when does that start?
So if you're captured by the legislation for the very first time, in these, we call them tranche 2 services. That's the vernacular that's been used in the industry. But if you're a tranche 2 service provider and you're captured for the first time, your start date for compliance is July 2026.
Right.
So you've got more than 12 months to comply. But that might seem like a long time, but in actual fact, there's quite a lot to do to be ready by July 2026. So, people should be, getting started with stuff now, so that they will be in a position to be ready. Now, if you're in a business that's already providing designated services, the changes to the Act also impact on existing arrangements under the Act. So, and those amendments come in on March 2026. And there are some big changes to the Act relating to what AML-CTF compliance plans need to do and customer due diligence and all that sort of thing. So there's effectively a rewrite of some of the parts of the Act that will impact on existing reporting entities as well.
Okay, so that's coming. That seems like it's a long time, but I'm sure it probably isn't, given the fact we're already at Christmas and away we're going. So look, what are some of the things, Ian, that firms are going to have to start doing to get ready? Because it sounds like there's quite a bit.
Look, there is quite a bit. And the first thing is to work out whether you're in or out.
Right.
So going through that list of designated services and saying, do I provide any of these designated services, and how important are they to my practice? It may be, depending on the nature of your practice, an appropriate response to say, I just won't provide that designated service anymore. But I think for most of us, that's not going to be a realistic option. So that's the first piece. I guess there is one piece of good news. The Financial Transactions Reports Act gets repealed from the 7th of January 2025. So potentially you have a lifting of the compliance burden for a little while, at least. But subject to that, most of it's going to be hard work next year. So the first thing is you'll need to do a money laundering, terrorism financing risk assessment of your business based on the services you provide and the people to whom you provide it. And then building on that, you'll be expected to build up an AMLCT of compliance program. Now, the compliance program will have a number of key elements. So the first one is customer due diligence, and that is understanding who your customer is and who owns them and what their identity is. Now, people who are used to dealing with AML-CTF compliance will be used to the existing rules, which are very, very prescriptive.
Yes.
And those prescriptive rules won't necessarily apply or satisfy or be necessary. It'll depend on your risk assessment.
Right.
But you'll have to have customer due diligence, and that includes before you start providing the customer designated service,
Right.
or ongoing. So there's an ongoing customer due diligence requirement in there. Now, the other piece that's important in there is to ensure that you have reporting procedures set up. So there are two key areas of reporting that you need to be aware of. Now, one of them is the threshold transaction reports, which is cash transactions over $10,000.
Okay.
So that makes up replaces the old FTERA.
Yep. Okay.
But that will only come in once you are brought in under the regime, the threshold transactions reports. Now, the other one is the suspicious matter reports.
Oh, I've heard about those. What are those ones?
So suspicious matter reports are effectively when you form a suspicion that your customer is involved in terrorism financing or money laundering. And there's also been a trigger for SMRs where the customer is not who they say they are. So they're lying about their identity.
Right.
And there are some strict obligations in terms of time and trigger points for SMR. And there's also obligations in the Act not to tell anyone that you formed that suspicion or made the report to AUSTRAC. That is being tinkered around within the legislation, and there are some changes to the tipping off provisions coming through. So you'll need to have suspicious matter reporting arrangements in place.
Right.
Now, I know you've been worried.
I am a little bit worried. I'm particularly worried then. Well, what does that mean for things like legal professional privilege?
So legal professional privilege is a matter that's been considered in the reform process. There is a mechanism that is being considered for preserving legal professional privilege. And what it appears to be is that there'll be some kind of a form called an LPP form. So we'll effectively lodge an LPP form to say there's stuff we can't say because it's subject to legal professional privilege. Now, we haven't seen what that form looks like yet, and that'll be something that we'll be monitoring in 2025 to see how that eventually pans out.
Right. So there's a lot of things involved in that, and I imagine there's a lot of additional territory for us to kind of cover. So that's probably pretty significant. I guess the interesting question is, well, what comes next?
So I guess we've got the Act.
Yes.
And as I said, there are some rules that sit underneath it. Now, we've had existing rules, but those rules are all about to be rewritten.
Right.
So understanding all the pieces of the puzzle will require a little bit of output from AUSTRAC for us to understand where we're going. The first round of draft rules has been released on the 11th of December.
Yes.
And we've got a fairly short time to respond on that,
Yes.
which is the 14th of February. So
Valentine's Day delight.
Valentine's Day massacre, yeah. And so we've got till the 14th of February to respond. That set of draft rules really deals with some of the stuff we've been talking about in terms of what's your compliance plan and customary due diligence and things like that. It doesn't cover all the aspects of compliance. So enrolment, registration and reporting, for example, they're not in there yet. There'll be a second round of consultation by AUSTRAC.
Yep.
But the one thing that we can see from the draft rules that's apparent already is that they're much lighter touch. They're very principle-based and very much building on flexibility and outcomes rather than prescriptive processes like these the safe harbour rules that are effectively in the current rules. So that means that the rules, the KYC rules, for example, they're going to be much thinner and principle-based. And overall, the AML-CTF compliant rules will be much thinner, I think. But there's a trade-off there.
Yes.
We're given flexibility, but the trade-off is with greater flexibility, there's also the potential for some uncertainty. Have I done enough to comply with my obligations?
Yep.
And I think AUSTRAC's recognised that there is that trade-off, and the government has recognised there is that trade-off. And the way that they'll deal with that is through the issue of guidance. So I suspect 2025 will be a big year for looking at the finalisation of the 2 rounds of rules.
Yes.
And then looking at the guidance. And some of that will be hopefully industry specific, or at least directed towards professional services so that it assists us with our compliance obligations.
So it's going to be quite an issue there trying to decide how much to do and where to do it, but really you're going to have to look at guidance as well as the rules and as well as the Act, trying to get the whole picture of what's going on.
Yeah, and then, look, one of my questions is, look, there's a role here for professional bodies like the QLS, and I know, Matt, you've already been involved in some of the dialogue. What's happening in terms of the QLS dialogue?
Absolutely. Look, there's probably best described as feverish consultation at the moment with AUSTRAC and with the government trying to clarify where the key points of concern are for the profession and where the key aspects are about trying to provide that industry-specific guidance so that AUSTRAC can come to understand that they're not naturally close to the legal profession and the way it operates on a daily basis. They've mostly come from the financial services industry. So this is a bit of a step change for them in terms of trying to understand a different approach. And so there's a lot of engagement at the moment trying to work them through the rules and guidance and those key elements that we really need clarified so that the profession can understand what it needs to do and have a bit of certainty and also a bit of comfort. So that's quite a very big thing that's going on at the moment that we're doing. Probably the other thing that's happening is that there's the Law Council Australia and the QLS have got quite a bit of guidance on our website already for practitioners, which is very introductory about money laundering and what it means and where it goes. AUSTRAC's developing quite a lot more guidance that will be a lot more detailed that we're helping them with. That'll also be incredibly useful as well. So it's a good opportunity to reach out and start to grab some of this stuff, I think. Is there a new website or something that's come out?
There's a new landing page on the AUSTRAC website for the reforms, and that came out just around the same time as they issued the consultation paper on the current round of draft rules.
Yep.
And there is some information on there that's useful.
Yep.
And I'll be watching out for the starter kits that they've been talking about as well, because I think that'll be a really interesting development.
Yeah, so they've talked about trying to create a starter kit where a small business, as they see them, can virtually pick up a a package and just start to implement it in their practice. That'll be interesting because there's no such thing as a standard legal practice that does the standard thing, but it'll be a great help, anything that they can provide in that particular space.
Yeah, look, there was a bit of debate about whether or not there would be a small business exemption for this legislation. There is none, and there's no general exemption for lawyers either. So, we're in whether we're MinterEllison or whether we're a two-man practice in the country region, and we're all going to have AML/CTF compliance measures in place.
Yeah, thank you. Look, Ian, it's an interesting adventure. It's one that we're going to go on. You and I understand, we're going to be back with a far more fulsome session early in the new year once we've worked through some of the current material and some of the current detail. And QLS has certainly got a mission to provide the profession with a lot more information, guidance and assistance on this. And we'll be back with a much bigger session in the new year.
Yeah, and I think the session that we run will be very much directed towards helping people map out the activities that they are performing, because I think there is only a limit to how far you can go in getting ready until some of the other material comes out. What's not going to change is that definition of designated services. They're set in the statute. So looking forward to that session later on.
Absolutely. Thanks very much.
Thank you.
Thanks for joining us.